Good afternoon, everyone. I'm Andy Kushner, co-chair of the Trust and Estates section. Welcome to our annual litigation update. Have a few housekeeping announcements before we get our program underway. First, you will receive your MCLE certificate, materials, and a copy of the program within 48 hours. After the program, please take a moment to complete the survey. A survey link will pop up right after we conclude the webinar. Today's webinar is sponsored by the Sanborn Team, Manufacturers Bank, and Wayfinder Family Services. The Sanborn Team has been sponsoring the Beverly Hills Bar Association's Trust and Estate section since 2006. Servicing clients for over 35 years, the Sanborn Team gives members and colleagues attractive results and peace of mind with a depth of knowledge of probate, trust, and conservatorship unparalleled in the industry. The Sanborn Team's ongoing sponsorship demonstrates a tangible commitment to the probate and trust community and the Beverly Hills Bar. They are ready to handle any and all sales of real property in Southern California. Think of them as the first resource for your real estate needs. Manufacturers Bank has been servicing the Beverly Hills professional business market for the past 60+ years. Its trust and estate group manages over $350 million in trust accounts. Brian Flores, Vice President and Senior Relationship Manager from the Beverly Hills office, is available to handle all of your trust and estate banking needs. Wayfinder Family Services is one of California's leading nonprofits. For over 60 years, Wayfinder has been evolving to meet the changing needs of our community. Wayfinder understands the unique challenges facing some of our state's most vulnerable youth and adults, those with disabilities, those without a home of their own, those who have been abused, and many, many more. Wayfinder sees them. Wayfinder believes in the amazing potential in each and every one of them. Wayfinder turns that potential into reality. Wayfinder invites you to join them in changing the future through your direct involvement or when you advise your clients on their philanthropic endeavors. You can learn more by visiting their website at wayfinderfamily.org. And with that, I will turn the mic over to Jennifer Campbell, our program co-chair, who will introduce our speakers today.
Thank you, Andy. I'm very pleased to introduce our speakers today, Scott Rahn and Nicholas Van Brunt, who have returned to update us on recent cases in the trust estates and conservatorship areas. They did such a great job. We couldn't wait to get them back this year. Scott received his undergraduate degree from the University of Wisconsin and his JD from the University of San Diego School of Law. He is a co-founder and managing partner of RMO LLC, and he represents heirs, beneficiaries, trustees, executors in resolving contest disputes and litigation related to trusts, estates, and conservatorships. Scott speaks and writes often and widely on trust and estates conservatorship litigation issues and is recognized as a super lawyer and an America's best lawyer. Nicholas received his undergraduate degree from UC Berkeley and an MA and JD from George Washington University. He is a partner at Sheppard Mullin, where he is a team leader of the firm's private wealth services team. Nicholas focuses his practice on resolving disputes in the trust, estates, and conservatorship area. He also has significant general business litigation experience and is recognized as a super lawyer and America's best lawyer. Thank you so much, guys, for joining us today. We are really looking forward to your program.
Thanks for having us. I'm just going to kick it off here, and Nick and I are going to go back and forth throughout the presentation today. For those of you who have seen this live, you kind of know how it goes. We're going to run through the cases and developments that have happened over the last year. We're going to ask that you hold your questions until the end, assuming that we have time, and then we'll go through them on the chat feature and try to answer any questions you may have. Nick, do you have anything you'd like to say before we get rolling?
No, it's great to see you. I hope everyone got their deliveries from Lowry's ahead of time so that we could enjoy a nice lunch. But yeah, I think if you look at the materials, the way we've broken it down is by topic area. It's a little bit loose, but so Scott and I will be going back and forth, but we're going to kick it off with Scott talking about a couple of cases that deal with everybody's favorite damages section, probate code section 859.
It's everyone's favorite because it's the muscle of the probate code, as we all know. The first case that we want to talk about is the Levin case. It is found at page 4 of your materials. It is a brand new case, a 2020 case, which basically stands for the holding that a bad faith finding is required for double damages under probate code section 859. In Levin, a daughter sued her stepmom for undue influence to invalidate amendments to dad's trust and sought return of assets under a prior iteration of that trust, as well as double damages under section 859. The trial court overturned one of the amendments that stepmom had gotten, but not another, but found that undue influence by itself was insufficient to award 859 double damages. The daughter, unhappy, appealed, and that decision was affirmed. The court basically said that without bad faith, undue influence by itself is not enough. Undue influence is merely excessive persuasion, not bad faith. So another slippery slope, a gray area, but you're going to have acts worse than simply cajoling someone into doing something that perhaps they wouldn't otherwise have done. The second case that we wanted to talk about regarding 859 double damages is the estate of Ashlock, which is a 2020 case. It's on page 5 of your materials. And that case stands for the proposition that section 859 double damages do not include restitution that has already been paid. Double damages means exactly that. It means double, so that the victorious party gets double damages plus restitution. In Ashlock, dad's friend had forged partnership documents and created estate planning documents naming herself as the sole beneficiary, into which she then transferred dad's assets using a power of attorney that she had gotten from him. After dad passed, the son moved to set aside the woman's misdeeds. At trial, the woman capitulated. It almost sounds like Nick was involved in this one. He tends to beat his adversaries into submission. Admitting that the estate planning documents were in fact invalid. I'm imagining tears and I'm sorry's and things like that. The court ordered her to return the $5 million plus in property that she had inappropriately taken, and to pay $10 million in double damages under 859, or a total of $15 million. She appealed, claiming that $15 million would be triple damages, not double damages. And the Court of Appeal affirmed, saying that 856, Probate Code Section 856, provides for restitution of property wrongfully taken from an estate or a trust, conservatorship. But that 859 provides for double damages in addition to the restitution that you're ordered to pay under 856. Sounds like triple, but it's really double.
Yeah, and I do know that there are some efforts with the various bar associations and with the California Lawyers Association to look at proposals to make 859 triple again rather than double, even though I agree with you, it says double, so it means double. But that would make it in line, I think, with other punitive damage statutes throughout the land. Moving on to another favorite topic, attorney's fees. We have the latest in the series of Attorney General versus Shine cases. This time it was Becerra versus Shine. This is not the first Shine case. In 2017, you may recall, Scott and I talked about this a few years ago. Shine was the trustee of a family trust with the residue going to the Livewire Linscock Foundation. It was a $40 million trust. And Shine was sued by the AG for removal and surcharge based on mismanagement. And an interim substitute trustee was appointed. Shine at that time petitioned for advanced fees to defend the petition, subject to repayment and indemnification. And the trial court had approved that, but the Court of Appeal reversed the pendente lite award because the trust was silent on interim fees and a strong case had been made to support removal and surcharge, and Shine would not be able to recover his fees if he lost. Fast forward to the outcome of that litigation that he was not able to draw upon the trust to defend, and he lost. He lost on most, if not all, of the claims that he had breached his fiduciary duties. He had allowed for improper tax returns to be filed. He had allowed a subchapter S corporation status to be lost. And he used trust fund to loan monies to friends, not Scott, but others. And as a result of his conduct, the trust was damaged significantly. He was removed as trustee, ordered to reimburse the trust in the amount of close to $1.5 million. And then the trial court granted the Attorney General's motion under Government Code Section 12598 to reimburse the Attorney General's attorney's fees and costs in the amount of $1.6 million and change. Schein appealed, and at the heart of that Crazy Diamonds appeal was 12598B, which says that the Attorney General shall be entitled to recover from defendants named in a charitable trust enforcement action all reasonable attorney's fees and actual costs incurred in conducting that action. And that includes expert fees and other stuff as well. Schein had an interesting theory. He conceded that the fee award was mandatory under Section 12598B, but that this, quote, changed nothing because only reasonable fees should be considered, analogizing to the private attorney general statute, and said that the courts were required to appraise the fee claimant's goals and results in the litigation, arguing also that he had only lost on 7 of the 19 claims against him or something along those lines. The Court of Appeal was not persuaded. It examined the statutes and the legislative history of 12598 and said that, by its own language, it doesn't require the trial courts to make findings about the extent of success or success at all. Unlike the private attorney general statute, it doesn't even require the attorney general to be a successful party. And the Court of Appeal further explained that the amount of the attorney fee award was not an abuse of discretion, even though the attorney general wanted some but not all of the causes, because, Schein was proven to be grossly negligent, to have, caused all these terrible things to happen to the trust. And, Court of Appeal said, too bad for him. So there you go.
The next case is Key v. Tyler, which, if this were Star Wars, I feel like we would be watching Return of the Jedi, perhaps waiting for the next and the next and the next episode, as long as we can skip episode 1. This just came down in 2020. It's on page 9 of your materials. The issues this time around are whether anti-SLAPP applies to a petition to enforce a no contest clause, and whether the defense of a subsequent document that acts to revoke a document with the no contest clause at issue constitutes a direct contest. The answer to both of which is a resounding yes. The plot women are back. The plot thickens, perhaps. I think the plot's always been quite thick. Really, it's just the same plot. I'll stop with the puns. You'll recall that Tyler plot got Mom to sign an amendment that reflected Tyler's, not Mom's, wishes. And that amendment was thrown out by the trial court originally, seemingly many, many years ago. The appeals abound and Taylor loses again. On remand, Key petitions to disinherit Tyler for contesting the valid trust by defending her illegitimate amendment. Tyler, in response, files an anti-SLAPP. The trial court says that the anti-SLAPP applies to the no contest petition, and Key loses because Key can't show a likelihood of success, despite the court's prior findings, which is a bit of a surprise. The court also finds that because Tyler only defended her defended her illegitimate amendments, it wasn't a direct contest under the statute. Key appeals, and here's the part where I see the Ewoks dancing at the end of Return of the Jedi. The appellate court finds that Key showed a probability of success, and in fact, she had already demonstrated that to such an extent that Tyler would be precluded from arguing otherwise. It was essentially res judicata. collateral estoppel. And Tyler's defense of her illegitimate amendment was a direct contest, because in effect, if she had been successful in defending that amendment, it would have acted to have revoked the prior iteration of the trust, which is the one the court validated. What's more, the court found that Key was entitled to, or should have been entitled to, costs and fees in the underlying action, and that there were contractual and equitable bases for both, which the trial court had denied her. So I guess all was right in the universe, although I can imagine Tyler somewhere plotting and scheming a resurgent with Sith Lord somewhere.
Yeah, the force will awaken, if I know the plot. So there's a case called Barefoot v. Jennings on page 11 of your materials. You may have heard of it. There were 24 amendments to the Maynard Family Trust, and Joan Barefoot, who was one of the children of the settlers, did perfectly well in the first 16, but she kind of lost out in the last 8 amendments. And she then filed a petition to invalidate those last 8 amendments on the grounds that her mother was incompetent to make them and that they were the products of fraud and undue influence. The defendants moved to dismiss the case under section 17200 and 17202, alleging that the plaintiff lacked standing because she was neither a beneficiary nor a trustee. The lower court agreed, and the Court of Appeal affirmed, causing shockwaves throughout the probate bar, because all of a sudden we're going to be looking at situations where we're having civil trials over trust contests, which would go against 100+ years of authority and statutory authority and public policy in California. Thankfully, the Supremes, by a resounding 7-0 vote, reversed, holding that when a beneficiary is eliminated by a trust amendment based on lack of capacity, undue influence, or fraud, that former beneficiary has standing if the invalidity of those amendments would render the party a beneficiary. And the reasoning is concise, but it's sound. The Probate Code section 17200 allows a beneficiary to petition the court to determine its existence, meaning that it contemplates challenges to validity. And Probate Code section 24 includes in the definition of a beneficiary those who hold present or future interests. And so the Supreme Court rejected the argument that this would invite chaos by allowing former beneficiaries to sue to invalidate subsequent instruments, because it only allows people in that limited subset to pursue those claims. It doesn't allow the world to come in. Interestingly, the Supreme Court also invoked Probate Code section 17206, which provides the probate court with wide latitude to make any orders and take any other action necessary or proper to dispose of the matters presented by the petition. And using such discretion, according to the California Supreme Court, the court can preserve trust assets and the rights of all purported beneficiaries while it adjudicates the standing issue. The Supreme Court made clear to say a couple points that this is a narrow holding. It's really just there to provide an orderly and expeditious mechanism for limited challenges, like a former beneficiary who was written out of a subsequent trust, to be litigated early in the probate process in probate court, and to ensure that the settler's intent is honored. And I think many of us breathed a sigh of relief when that ruling came down. We now have, this is me again, we have a slew of conservatorship cases that I'm going to run through relatively quickly. There's 5 of them. The first one in your materials is Conservatorship of D.C. And the key issue in that case was whether the conservatee's failure to file an appeal of the order granting the conservatorship letters barred appellate review, and it did. What happened there was D.C., who had a significant history of psychiatric illness, was admitted to a psychiatric hospital in July of 2017. Subsequent to the 30-day and 14-day holds, the public guardian was appointed as a temporary conservator in August of 2017. A hearing was held with D.C. having counsel present, saying that D.C. would submit to the conservatorship, and it was granted in October 2017. 60 days go by, no appeal. Later on, D.C. petitions for a rehearing and demands a jury trial in January 2018, which D.C. loses, the jury finding that the conservatee was gravely disabled under the LPS Act. And the trial court ordered that the conservatee remain under the conservatorship, and that all prior orders would remain in effect. The conservatee appealed, arguing, glad you're back, Scott, that the trial court failed to advise her of a right to a timely jury trial and lacked the authority to accept the submission without her consent, and that the belated jury trial did not cure the prejudice, all of which may have been good arguments, except that she blew the 60-day appellate deadline in the first place. So this is a nice reminder to follow the 60-day jurisdictional appellate guideline. Moving on to Conservatorship of A.E, which is on page 13. This is listed under LPS because it has a public guardian involved, but it actually is technically a normal probate conservatorship case. It was actually a limited case. There you had a proposed conservatee who was a 26-year-old with autism who did not want to attend the hearing on her petition. And, and then the petition was granted. And then she appealed, saying that she had not been there to appear. And the issue in the case was whether the requirements of Probate Code Section 1825, which require the in-court presence of the proposed conservatee unless an exception applies, were met. And if not, whether the failure to make such findings was fatal to the order. And the answer was the requirements were not met, and that was fatal. As a quick refresher, Evidence Code Section 1825 says that the proposed conservatee shall be produced at the hearing, except in the following cases. If the proposed conservatee is out of state, is unable to attend the hearing because of medical inability, or the proposed conservatee has expressly communicated an unwillingness to attend, desire not to contest the conservatorship, and no objection to the proposed conservator, and the court makes such an order. None of those things happened in Conservatorship of A.E. Simply put, for whatever reason, the proposed conservatee doesn't show up to the hearing. The record is silent as to whether any advice was given, as to whether or not she, had to appear, and therefore that was the end of the story, according to the Court of Appeal. And so this is a good reminder that, especially to those of you who act as court-appointed counsel, that it is vitally important that the strictures of Probate Code Section 1825 are met for your client. And if you are the petitioner or the proposed conservator, it's the same deal. You need to make sure that those requirements are met, or you may be facing reversal down the line. We do now have 3 LPS cases, the first of which is Conservatorship of D.P, which starts on page 14 of your materials. That's an interesting one. That one shows the perils of relying on jury instructions. In Conservatorship of D.P, the finding that the conservatee was gravely disabled did not require a finding that the conservatee was unwilling or unable to voluntarily accept medical treatment. Even though KG 4000 does have that as an optional provision of the jury instruction when it comes to gravely disabled. And the Court of Appeal goes through a pretty lengthy exposition of the history of what gravely disabled means. And what gravely disabled means is that you're either unable to provide for your basic personal needs for food, clothing, or shelter, or you're mentally incompetent under the penal code. And neither of those include the requirement that you be unable to voluntarily submit to medical treatment. Now, that can certainly be a factor in determining whether you can meet your basic personal needs, but that is not a statutory requirement for the finding of being gravely disabled. There's now a circuit split on an issue that we may very well see in the Supreme Court on the issue of whether a proposed conservatee in an LPS matter needs to testify, is required to testify at that civil proceeding. And you have the conservatorship of Brian S. and the conservatorship of E.B, which are found on pages 15, 16, and 17 of your materials. Brian S., though second in your materials to keep you on your toes, we'll talk about first because it preceded the second case. And in Brian S., the Court of Appeal ruled that in LPS proceedings, proposed conservatees are unlike others that are subjected to civil commitments, such as persons who are found not guilty by reason of insanity, or sexually violent predators or mentally disordered defendants, and therefore they do not have the right under the Equal Protection Clause of the United States and California Constitution's clauses to refuse to testify because proposed conservatees have not committed a criminal act. The Court of Appeal in Bryan S. did acknowledge that LPS conservatees, like those found not guilty by reason of insanity or sexually violent predators or mentally disordered offenders, are subject to involuntary civil commitment as a result of their mental health, but the distinguishing factor is that the others are criminal in nature, where an LPS is not necessarily a criminal proceeding. Subsequent to that, the Conservatorship of E.B. criticized the court in the Conservatorship of B.S., saying that although there is no, Brian S., saying that although there is no explicit constitutional right not to testify against oneself in conservatorship trials, and that the LPS Act doesn't create this statutory right, that LPS conservatees are similarly situated to those who are not guilty by reason of insanity, and therefore forcing an LPS conservatee or proposed conservatee to testify at trial would violate equal protection in the same way as those who are not guilty by reason of insanity. And they call out Bryan S. By name, saying that they're similarly situated. They're both in involuntary civil commitments, but because the error was harmless in this case and there's plenty of other evidence, they affirmed anyway. And this will be interesting to see what the Supreme Court does with this. But right now, it's very much in question, I think, as to whether an LPS conservatorship requires that the conservatee be compelled to testify against oneself. And on to Scott.
So the next case I wanted to talk about is the North Carolina Department of Revenue versus Kestner. It's a beneficiary income tax case. It's from last year, 2019. It's page 25 of your materials. In the North Carolina case, the Supremes weighed in, the U.S. Supremes, on a case that seems like it never should have gotten there, to hold that a resident must have possession, control, or enjoyment of trust property to be, to be taxed on it. Here we were dealing with a New York trust, a New York settlor, and a beneficiary whose trustee had absolute discretion to make distributions, and which trustee had actually made 0 distributions. One of the daughters had moved to North Carolina, where she lived for 4 years. And North Carolina sought to assess a tax on the full interest of the trust for those 4 years, which the taxpayer paid under protest, and then sued in state court, claiming that the daughter's relationship to North Carolina was too tenuous and that the state's taxing of her violated the due process clause. The taxpayer won at the state court level, and the state appealed and lost. Appealed again to the North Carolina Supreme Court, where they also lost. And you would have thought that if you can't, as a state, if you can't win at your own state Supreme Court, it might be a place to stop. But undeterred, they continued on and sought cert and were granted cert by the Supremes, who affirmed and essentially said that here, where the resident taxpayer has received no benefit, again, has no possession, has no control, has no enjoyment, essentially has no right to receive the benefit upon which they're seeking to tax the taxpayer or would-be taxpayer, you simply cannot tax, and it is a violation of the due process clause.
We're going to move back up for a minute to page 22 to the fiduciary duty section. We've got 2 cases, Estate of SLAPP and Donkin v. Donkin. In Estate of SLAPP, in Estate of SLAPP, Roscoe died in 1994, and he was survived by 7 children. And in 2001, the court instructed the then administrators to sell property. Seemed like long enough at the time, 7 years, and ordered the co-administrators to submit a formal order, which they never did. Those former administrators died, and then someone named Rogers becomes the sole administrator in 2005. In the 14 years following the 2001 order, the court did approve the sale of 4 of the properties, but there were 9 other properties owned by the estate that were not sold, and Rogers had made no other progress. During that time, Rogers listed the property for about 50% in excess of its appraised value and let it go down so that it was basically unmarketable, and also tried to buy out the other beneficiaries for a crazy low sum of $10,000, which was considered later by the court to be in bad faith. So two grandchildren filed petitions to remove Rogers, and the court found that the removal was appropriate, the lower court, because of the substantial delays in the administration, which they believe were intentional. This all seems relatively straightforward. If you, as a administrator of an estate, can't get your act together in a 15-year span, they probably need to move on. But interestingly, the Court of Appeal, while affirming the ultimate result, did say that the lower court incorrectly construed Section 8502 of the Probate Code. The lower court had relied on 8502B, which says that a personal representative can be removed if the personal representative is, quote, incapable of properly executing the duties of the office or is otherwise not qualified for appointment as personal representative. The lower court had said that the personal representative was essentially incapable, meaning incompetent, but the Court of Appeal said what that really means is incapable, i.e. mentally incompetent, not necessarily functionally incompetent to do the job. But that in any event, the administrator was clearly not qualified for the appointment as personal representative at that point, and beside the point, it acted in bad faith, and that was an independent basis for removing the fiduciary. The next case is Estate of Donkin, which is another, I don't know if it's a trilogy exactly, but it's a repeat visitor. In Donkin, Rodney and Mary, just to give a little historical background, they settled the trust in 1988 that they amended in 2002 with their primary beneficiaries being their children. And the trust provided that on the death of the first trustor, you have the survivor's trust and then a marital share, and then on the death of the surviving spouse, the marital share would divide into trust B and C. After the death of the first spouse, which in this instance was Rodney, trust A was still revocable. That was the survivor's trust, but B and C became irrevocable. We see these estate planning maneuvers every day. Nevertheless, in the intervening time between Rodney's passing and Mary's passing, she signed a trust amendment that, without specificity as to referring to A, B, or C, amended the trust, which had contained spendthrift clauses, instead to give which had called for straight distributions, to include spendthrift clauses that gave the sole discretion as to the distribution of income and principal. And then the trustees purported that that had amended trust B and C. Back in the early teens of this millennium, there was a case that questioned whether the petition filed by the beneficiaries to set aside that instrument was in effect a contest, and the determination was that it was not a contest because it was really a question of interpretation, and this was not saying that the instrument was void for lack of capacity or undue influence, but that literally it was an ultra vires act. You cannot amend a trust that's irrevocable. Fast forward to the subsequent litigation, where the trustees who were self-represented tried to push their theories once again, and specifically said that this was a continuing discretionary spendthrift trust, and they filed a petition for instructions clarifying that issue. The beneficiaries took issue with that and also said, by the way, trustees, you can't represent yourself. That's the unauthorized practice of law. The trial court concluded that the trust was not a continuing spendthrift trust, but that the trustee, because this was an internal matter, could in fact, the trustees could represent themselves, notwithstanding the fact that in other cases, trustees cannot represent themselves. And the distinguishing factor is that if it's internal to the affairs of the trust, a trustee is not out there advocating on behalf of the trust itself, but against the beneficiaries. And therefore, that is not unauthorized practice of law. It's when you go ahead and defend a trust or prosecute an action on behalf of a trust against a third party that you are acting effectively as a lawyer on behalf of the trust. And that was the holding. But there was a note of caution from the Court of Appeal, who's getting tired of seeing Donkin cases, I believe, saying, we note that the trustees have wasted both the courts and beneficiaries' resources and time trying to relitigate issues already decided by the California Supreme Court in this case, and we are cognizant of the possibility that had the trustee been represented by an attorney, this may not have occurred. But whether trustee must be represented by counsel in future proceedings will depend on the nature of the trustee's efforts in those proceedings, considered in light of our decision in the case law discussed above. So there's a little bit of an opening there, but I think right now the answer is trustees can represent themselves in pro per.
Stay tuned, more to come on this one.
Yeah.
The next case I wanted to cover is the Placencia case. It's Placencia versus Strich, and it deals with the issue of modifying joint tenancy accounts with a right of survivorship. It's a 2020 case. It's on page 27 of your materials. The holding of the case is essentially that a joint account with a survivor can be challenged with clear and convincing evidence of other intent, which is not shocking to any of us. In Placencia, the dad left a joint account with a right of survivorship to his daughter, Lisa, but made it clear in his other conversations and in his will that all three of his daughters should split that account equally. Account had a couple $100,000 in it. After dad passed, Lisa refused to share with her sisters. One of her sisters petitioned the court essentially to order her to put the joint account assets into the estate. And the trial court found that there was clear and convincing evidence, including from dad's will, that he intended that the accounts be split equally amongst the girls. Lisa appealed, claiming that dad had not taken any of the steps to change the account, the nature of the account under section 5303, and that under 5302E, dad could not change the account structure by his will. The appellate court disagreed. The appellate court essentially said that 5303 really is just there for bank protection. It really sets forth a number of different procedures that the banks can and should follow without repercussion for changing and how these accounts can be changed. And that his will, while instructive, did not act to effectuate a change in the account structure under 5302E, but it was evidence of his intent, and it was sufficiently clear evidence, clear and convincing evidence of his intent that all three daughters should take from that account, and therefore affirm the lower court's ruling. The next case I wanted to cover briefly is Gonzalez versus City National. It's a 2020 case. It's page 36. It's at the back of your materials. Essentially, it stands for the issue of whether a special needs trust can be liable to the California Department of Health Care Services for benefits that the trust beneficiary received from the state, even though they were under 55. And the short answer to that is yes. The state has a right to recover. There's a lot of policy reasons behind it, obviously, and the opinion goes into a lot of those, which I'm not going to cover here for you today. I don't think it's a total shock to people.
Sorry, my 8-year-old paralegal is here. Hey, buddy, I'm giving a presentation. Okay.
You've got a strong team, Nick. You've got a strong team.
All right. Let's move on to Ravi Jelly, which is an interesting case about notice and due process. That's found on page 30 of your materials. In Ravi Jelly, you had McKee Sr. and his wife who had 3 children, and then he got married to Yvonne, his second wife, and he created a trust for Yvonne with a power of appointment. And if that trust power of appointment was unexercised, then the trust would devolve in quarters at Yvonne's death to McKee's 3 children and Yvonne's child. And if the child did not survive Yvonne, it goes to the child surviving issue. After Senior died, there were claims raised against the estate that were resolved in a petition to approve the will in 1991, and the settlement resulted in trust being distributed to Yvonne's son in the event that she did not exercise the appointment power. All the children were given notice of the settlement, and they in fact decided to forego their interest in the estate as part of the settlement. And the grandchildren who were not given notice were eliminated from the distribution scheme. Mark, who was McKee Jr.'s son, in 1991 was an adult, had a known address, had a known name, Mark, but he was not given notice in 1991. And then after Yvonne, many years later, 25 to be exact, failed to exercise her appointment power prior to dying, he sued, saying that the decree approving the settlement in 1991 was void because he never received notice. And the trial court ruled that, let's see, your father received interest and disclaimed it, and it was 30 years ago, and you had a contingent remainder, so no. See you later. The Court of Appeal reversed, holding that Mark was entitled to notice. And the due process requires reasonable notice of any proceeding affecting a property interest. And it cited the Mennonite versus Adams Supreme Court case from 1983, which says if a proceeding will adversely affect a person's property interest, due process requires that the person be given notice by mail of the proceeding and an opportunity to be heard when the person's name and address are reasonably ascertainable. Mark had a property interest, and yeah, maybe it was subject to divestment, but he had a contingent future interest. And that was, according to the Court of Appeal, that was the end of the story. This may end up going to the California Supreme Court, so I would stay tuned on this one. That said, it is kind of a logical result from a due process perspective. Now, whether a laches argument maybe could have been raised, I don't know. That, it has been 30 years. On the one hand, maybe it wasn't ripe until Yvonne, failed to execute her power of appointment. On the other hand, did he have knowledge of it? There are probably factual questions there, but this should be a cautionary tale to all of us that you can never give too much notice.
It's a great lesson. Absolutely. The next case I want to cover is Hahn versus Hubbard. It's on page 28 of your materials. It's a 2019 case, came down last year, regarding transferability, limitations on transferability of partnership interests. And the case essentially stands for the proposition that transfer of a partnership interest to a trust can act to circumvent a buyout provision on that partner's death. This case deals with a couple dentists who formed a partnership in a dental office and a dental practice. They later modified their partnership agreement to add a buyout provision on that partner's death or transfer. One partner asked to transfer his interest to his trust, and all the other dentists agreed. And this is where I love dentists. My best friend's little brother is a dentist, and I get random calls from him periodically, perhaps too often, asking how to get out of things that he shouldn't have done. I'm not saying all dentists act that way, but that's just my own personal experience. So the partner who had his interest transferred to his trust steps down as trustee of his trust as he's getting ready to retire, makes his son the trustee. Subsequently, the partner dies. The partners then seek to enforce the buyout under their agreement, thinking that they have the right to do that. But now the trust, and not the deceased partner, is the partner. Still, they try to enforce it, bringing suit, claiming that the trustee and trust can't be a partner, and they lose. They had agreed to it. They appeal, and they lose again. And the appellate court essentially says that the California Partnership Act expressly defines person to include trusts. So they essentially had gotten into a deal, and if they had probably asked their lawyer at the time that the partner asked if he could transfer his interest into the trust, would have had an opportunity to address that issue at that time. The bottom line is that dentists make great dentists, often bad business people, and almost always worse lawyers.
I feel like all the partnership cases that we deal with in probate involve dental practices. Maybe a couple of their legal practices, but usually dental practice.
Almost always. Almost always.
Yeah.
Which is entirely consistent with my experience.
Yeah. So we should probably do some sort of cross-selling with the dental associations, but I digress. What would an update be without a creditor's claim case? Well, we have a state of Holdaway, which is kind of a novel case where you had a timely creditor's claim filed by a creditor who filed a probate 2 days before the 1-year statute expired under 366.2, but then lost in the, eventually lost, but first, after several continuances, had her probate petition denied without prejudice. And in the intervening time, she refiled it after some additional time, more than 2 days had passed. And then the son of the decedent filed a competing petition and was eventually appointed personal representative, and the creditor's petition was dismissed. And then during that whole time, the creditor claim had never been rejected. And finally, when the son was appointed, he then rejected the creditor claim, and within 90 days thereafter, the creditor filed a creditor suit, and the son demurred, arguing that the complaint was time barred under CCP 366.2 and otherwise barred by other statutes of limitations, which the trial court sustained, but the Court of Appeal reversed. And saying that it was an issue of first impression, the Court of Appeal held that the trial court's dismissal of the creditor's own petition to be appointed as a representative of the estate did not terminate the tolling of the statute of limitations under 366.2 that was triggered by the filing of her creditor's claim. And therefore, unless and until under Probate Code Section 9352, that claim was acted upon, i.e. allowed, approved, or rejected, that the statute of limitations was tolled for that entire period. So that argument was dismissed. The executor had a couple of other interesting novel arguments. One was that the 1-year statute recommenced when the probate petition was dismissed and was expired 2 days later. The Court of Appeal used the same reasoning to explain why that didn't work. Then the personal representative argued that the suit was not timely filed because the 90-day limitations under 9353 for filing creditor suits. So after your creditor's claim is rejected, under Probate Code Section 9353, you have 90 days to file your creditor suit. That statute had all but run because she had waited until 364 days to file. That was a novel argument, but that was also rejected. The Court of Appeal did, for other reasons, sustain the demur with leave to amend because the nature of the creditor claims themselves were uncertain. And by the way, just as a practice point, it's probably not good enough to say that you have a creditor's claim because of some household expenses that are undefined and some services that are undefined. That was insufficient according to the Court of Appeal. So that's something to keep in mind as well if you're representing creditors. Otherwise, it's hard to see this situation coming up all that often, but it was kind of a fun exercise.
The next case is Tubbs versus Berkowitz. It's one of two power of appointment cases. Tubbs is a 2020 case. It's on page 32 of your materials. The issue there was whether a trustee can exercise a power of appointment for his own benefit when it comes at the detriment or causes detriment to the other beneficiaries. even though he's expressly authorized to do so. Harry Berkowitz and his wife set up a standard A.V. trust. Wife died. The subtrust were funded. The marital trust gave Harry a general power of appointment, which he exercised for himself, disinheriting his kids and grandkids, who are the remainder beneficiaries. Probably made the holidays and birthdays a little difficult. Daughter, in response, sues dad as trustee, saying he breached his fiduciary duty to them as the remainder beneficiaries. She lost and appealed, and the appellate court affirmed, basically saying that dad had the express authority under the trust to do what he did, so he could not, by definition, have violated any duty he owed to them as remainder beneficiaries. The second case is not in your materials. It just came down. It's the Eimers case. And if anybody doesn't have a copy and wants a copy of it, email me. I'll be happy to send it to you. And this is an opinion from our own Judge Stratton. And it contemplates the question of, can a will that fails to comply with the specific requirements as to how to exercise a power of appointment be reformed to meet those requirements and work around the specific statutory scheme laid out in Probate Code sections 630, 631, and 632? The answer to which is no. Mom and Dad's trust had a general power of appointment authorizing appointment by will that specifically referenced and exercised the power of appointment. Son, in a holographic will, simply wrote, "I leave my shares of the trust to A and B." After he passed, the trustee of Mom and Dad's trust initiated a proceeding to determine whether that exercise of that power of appointment was sufficient. And the trial court said no. The heirs tried to make an end around that ruling and sought to reform the will, claiming that it was the decedent's intent that they take and that they receive his share of the trust. And which is one of my favorite arguments of all times, the trust was a big document. And these are just technical words. They don't really mean anything. The intent should control. It was only a 30-page trust. So we've all seen tomes that make 30 pages pale in comparison. The trustee demurred to the heirs' efforts, and that demur was granted. The heirs appealed and lost. Judge Stratton essentially wrote that 630 et sec requires specific compliance, and a reformation is simply an end around those statutes and is not the answer. So it's a good quick read, and it's nice to see Judge Stratton's name again. Next, I want to run into, I've got 4 cases, and I realize we're at 125, so I don't know if this is the lightning round. We'll see if we can get through it. I've got 4 cases on testamentary intent. They're Wilkins, Sachs, Pena, which are on pages 18, 19, and 20 of your materials, and then a new case that just came down, Robertson v. Sadat, which again, if you don't have a copy, email me and I'll send you a copy. I'm going to start with Wilkins. It's a 2020 case. That's the one that's on page 18. And you can kind of compare and contrast this with Eimers that we just talked about. The question there was whether a pour-over will can be reformed where there is clear and convincing evidence that the decedent had a different testamentary intent than that which was stated in the will. In this case, Mom intended to give her sons a separate property, rental property, and to leave the rest of her estate to her husband, who was the son's stepdad. But she executed a pour-over will that gave her entire estate to the trust that had been established to hold the separate property for her sons. Mom dies, and the sons tell the stepdad, "Too bad, so sad. Mom didn't do what you thought she should have done." Dad petitions to have the will reformed, and the court found that there was clear and convincing evidence that the sons were only supposed to get the house, and reform the will to provide the rest for Dad. The sons appealed, and the appellate court affirmed. essentially hanging their hat on the estate planner's testimony. The estate planner had testified that it was mom's intent that the boys only get the separate property house, and oddly testified that she and mom had never discussed community property or community property issues, much less that the community property was going to go to the trust and the boys. The next case is Sachs. It's on page 19, again, a 2020 case. The question there was whether a beneficiary's emails in which the beneficiary had conceded gifts received during dad's lifetime and decedent's logs, handwritten logs, were sufficient to establish that those gifts were in satisfaction of testamentary gifts that the decedent father had made. Dad had kept a permanent record, which I have never seen mine. Nick, have you ever seen yours?
Twice. Just kidding.
I'd hate to see what's on mine. Dad kept a permanent record. That was his term. I mean, I love these cases. I love what we do. He kept a permanent record of monies that he had distributed to his children over their, I'm guessing, their adult lifetime. I doubt it went back to when they were children. Dad dies. Sister is the trustee of dad's trust. After dad dies, son continues to ask for distributions from the trust, and sis obliges, but says, this is going to go on the permanent record. And the son emails sis to say, yeah, put this on the permanent record. We'll square up later. A year of this goes by, and sis comes back to ask her brother to equalize, and he plays dumb, plays possum. I don't know what you're talking about. We're not going to equalize. We need to split the trust down the middle. Whatever we got is what we got. Sis petitions for instructions and wins. There was about a little less than $500,000 at stake. But the son appeals. Gotta love these people. He said the permanent record was not sufficiently authenticated, and that his emails, well, those are really just insufficient to really establish anything, really. Not surprisingly, the Court of Appeal affirmed, said that the permanent record that dad had kept had been sufficiently authenticated by sis, and that permanent record was sufficient to satisfy or prove satisfaction of gift by the transferor under 21135A2, and separately that the son's emails were sufficient to establish satisfaction of gift as acknowledged by the transferee under 21135A3. Pena is the next case. It's a 2019 case. It's on page 20, and it deals with the issue of whether interlineations made by a settlor to a trust were sufficient to modify that trust. The short answer is no. Here, the settlor wanted to amend his trust. The estate planner told him, go ahead and mark it up and send it to me, and then I'll make revisions and get them back to you. He marked up the documents, sent them to the planner, was unable to consummate the transaction prior to passing, and the beneficiary who was seeking to benefit from those interlineations sought to have them enforced as a modification. There was specific language in the trust, specific modification requirements, which the trial court and appellate court said you have to comply with. While there may be some two different statutory schemes for revocation of a trust, there's only one way to modify a trust, and then it's by its specific terms. The last case on testamentary intent is the Robertson versus Sadat case, which is also hot off the presses. And that case stands for the proposition that a donor's intent controls disposition of the gametic material after their death. The desire to have a child pre-death is insufficient to control what happens with that gametic material post-death. Here, sad case, really. Husband had donated sperm pre-death, died an early death. 10 years later, his wife decides that she wants to have a child using his sperm. The doctor and lab that they had used to collect the specimens had lost them. And you can imagine how distraught she must have been, even after all these many years and all the plans she undoubtedly had made for what her future family would look like. So she sues the doctor and the lab for breach of contract, tort claims, emotional distress, all these kinds of sorts of things. And the lab and the doctor demurred, basically claiming that she did not have a legal right to use the sperm in any case. And the trial court granted the demur. The wife appealed and the appellate court affirmed, essentially holding that despite the plethora of evidence that the wife had, cards, notes, etc., testimony about how her husband had wanted to have a child and had expressed wanting to have a child with her during their lifetime, because there was no specific intent stated as to what he wanted done with that material after he died, she had no right to use it. So interesting case, good quick read.
It is a sad one. I see we're at time. I don't know. I see a couple quick questions if people are still on. Scott, there's one from Adam Streltzer, which normally I would punt to you, but it's about Barefoot, so I'll take it. Hey, Adam. Thanks for the comments on the haircut. The question is, do you believe forgery is included within the penumbra of Barefoot and Jennings, because it isn't listed in the opinion? I would think so. I agree it's not listed. The same logic would seem to apply to any traditional trust contest, I would think. But no, it's not listed as one of the items under the Barefoot opinion. So I suppose somebody could make a contrary argument. I just think that the logic is the same, which is that if you're a former beneficiary in prior instruments, you have standing to proceed if you're written out later, So, and then
the issue is because they did cover it, because it's not enumerated in there, is you open the door to having to have to go through this process again.
Right. Which is interesting though, because I mean it's otherwise enumerated in the statute, right? Then there's a question for you, Scott, from Robert Briskin on the Key versus Tyler. What could the attorney have done differently? That's probably a long.
Bob, call me. We'll set up a private Zoom and we'll go through all the things. It's more of a happy hour discussion, really.
Yeah. And then I guess
I'm sure Nick would join that.
Yeah. Important question from Kenneth Wolf. Where is my roast beef lunch? It's on its way, Ken. And William K., do you request probate code 859 damages in the petition for breach of trust? I mean, you could, right?
Depends on the facts of the case.
Yeah, that's one vehicle. It used to be under the prior formulation that 859 really was pertained to 850 petitions, right? That's why it's in the same section. But once the elder abuse statutes were revised several years ago, 859 was expanded to apply there, and I think now, yes, I mean I think 859 could apply to a petition for breach of trust. I think that's it in terms of questions.
Thanks, everybody. Appreciate the opportunity to present. Thanks, Nick. Great job.
Good to see you, Scott. Thanks, everybody. Thanks, Jennifer. Thanks, Linda. Thanks, everybody.
Stay well, guys. Hope to see you, actually see you all soon.
Yep.
Thanks for a great presentation, guys. Really enjoyed it. All right, have a great afternoon, everybody. Bye.
Take care, everyone. Bye.